Elvin, Cooper Estates, Strategic Land Limited and Wiltshire Council and Others.
Yes, Mr. Brown.
My Lords, I appear for Wiltshire Council, the appellant in this matter, with my learned junior, Mr. Stephen Morgan, Mr. Gregory Jones, Queen's Counsel, and Mr. Philip Petchy appear for Cooper Estates, the respondent.
You can take it that we have read the judge's judgment, the various skeleton arguments, the list of issues, and what we would like to do is to hear you both on the appeal before proceeding with the respondent's notice, if we need to.
I'm grateful for that, thank you. My Lords, just by way of housekeeping, can I check? You should have the two lever arch folders, which were the larger ones which go with the main appeal. There is a slimmer supplementary bundle which relates to my learned friend's cross appeal, should we get there. There is also a bundle of authorities.
Sorry, which is it? The cross appeal is core bundle 1.
Core bundle 1, core bundle 2.
Core bundle 2 is all the various questionnaires.
It's the various questionnaires, my Lord, and then
the supplementary bundle has a lot of the planning documents in it.
Yes, and indeed some of the correspondence as well, my Lord, and it's there, as I understand it, principally in relation to, as I say, my learned friend's cross appeal. My Lord, that's right. The policies themselves we will need to go to. Yes, I'm entirely right. And your Lordship, I think, indicated you'd seen the list of issues, which I hope was at the court yesterday. Good. My Lords, in that case, you will know that this is my appeal from the decision of Mr. David Elvin, Queen's Counsel, sitting as Deputy High Court Judge, in which he allowed a challenge by the respondent to my client's decision to register land at Vowley View in Wootton Bassett as a town and village green. My Lord, in terms of roadmap for my submissions, I start by taking your Lordships to the legislative framework. I want to say a little about the factual background. In many respects, the factual background is neither here nor there. It's a pure point of law, but I take your Lordship at least to the policies of the development plan and the way that they were considered by the Council at the time. My Lord, I then move from there to my submissions. I start with outlining to your Lordships the way in which, in my submission, the legislative framework should be applied to the two key policies, that's policies CP1 and CP2, and then, my Lord, to comment on the way in which the matter was dealt with by the Deputy Judge below. So, my Lord, starting with the legal framework, if I could ask your Lordships to take up the bundle of authorities. Your Lordships have at tab A the Commons Act 2006. And my Lord, for present purposes, the starting point is section 15, which is the section which establishes the right to apply to register land as a town or village green.
Yes.
And your Lordships will see, subsection 1, any person may apply to the Commons Registration Authority to register land to which this part applies. And my Lords, in sections 2, 3 and 4, there are then sections dealing with different aspects of the timing, different scenarios. Subsection 2 deals with uses of the land as a town and village green which are continuing at the date of the application. Yeah. Subsection 3 is a situation where uses ceased before the application was made, but after commencement of the Act itself. And section 15, subsection 4, deals with uses which ceased before commencement of section 15. In the present case, my Lord, we're in section 15, subsection 3 territory.
Subsection 3?
Yes. Inasmuch as the use had ceased because the land had been not only gated but bolted, and that had prevented use, and that was the event which led to the application being made. My Lord, nothing in particular turns on that. What I do at this stage, my Lords, draw your attention to is that whether one is in subsections 2, 3 or 4, the applicant needs to demonstrate the same thing, essentially, namely that a significant number of the inhabitants of any locality or any neighbourhood within a locality have indulged as of right in lawful sports and pastimes on the land for a period of at least 20 years. Provided those criteria are met, there is a right to have the land registered. My Lords, I pause at that point simply to note that town and village green status is thus expressly tied to, indeed it depends upon, the existence of a locality or neighbourhood which has a sufficient number of inhabitants to use the land in the required way.
Yes.
Now, my Lord, I don't say that that is something which can only arise in an urban area. Quite clearly it can arise elsewhere. But it is some significance that the section requires a community and that, or a locality, a neighbourhood, and that in my submission, neighbourhoods or localities which will provide the number of inhabitants required are, by definition, more likely to arise in existing urban areas. It goes without saying that there are going to be more neighbourhoods or more communities in a city than there are if one moves, for example, out to the parishes. The bulk of the population is going to be in a neighbourhood or community in an existing urban area.
It's called village green.
Well, it's a town or village green, my lord, and indeed I've certainly sat as an inspector on town and village green inquiries in the centre of London, well, not in the centre of London, but in London.
It covers both.
My lord?
It covers both.
My lord, it covers both, yes. And there's no, for present purposes, there's no distinction between town or village green. It's called a village green, but it can exist in any number of places. And indeed, a wide range of areas of land have been considered a village green, even though they are not your typical idyllic cricket pitch with a clubhouse. Or indeed anything that might normally be considered a village green or a duck pond. But my lord, I do make the point that the existence relies upon the fact that there is a neighbourhood or a locality, a group of people, and that has some bearing in my submission in terms of the implications of the judgment below for the right to apply in this case. So, my lord, that's the essential right to apply for registration. Your lordships also know, and this is the relevant provision for the purposes of argument today, that right has been the subject of further restriction, which was inserted into the Act in 2013 as Section 15C, which your lordships have next, still within the same tab, but turning through, it's misleadingly numbered page 1 again. My lords. 15C, registration of village greens exclusions, the right under section 15.1 to apply to register land as a town or village green ceases to apply if an event specified in the first column of the table set out in the relevant schedule has occurred in relation to the land. That's a trigger event. And then subsection 2, where the right under section 15, subsection 1 has ceased to apply because of the occurrence, it becomes exercisable again only if an event specified in the corresponding entry in the second column of the table occurs in relation to the land, a terminating event. And your lordships will note there is then power given to the Secretary of State to add trigger events and terminating events subject to subsection 6, which says that it must be an event related to the development, whether past, present or future, of the land. So, my lord, that's section 15C itself. It needs to be read alongside the schedule which sets out the trigger events and the terminating events. Your lordships should have that at the next page of tab A. Your lordship will see in the right-hand column a number of events described. The first is an application for planning permission or permission in principle. Second, an application for permission it's a different type of application which may be made under the Act. The third, a draft of a development plan which identifies the land for potential development is published. And then, and this is the relevant provision for the purposes of this appeal, number 4, a development plan document which identifies the land for potential development is adopted under the relevant sections of the 2004 Act. My lord, that's the trigger event. And the terminating event, or corresponding terminating event, is the revocation of that document, or the fact that one of the policies or the policy which identifies the land is superseded by another policy in relation to the Act. So your lordship will see, first of all, that section 15C and the schedule associated with it do not necessarily extinguish a right to apply to have land registered. What it does is effectively to suspend the right while a trigger event remains effective. And of course, in certain circumstances, that suspension may become permanent, so effectively the right is terminated, but that's not an inevitability. And as far as the relevant trigger event here, development plan document, which identifies the land for potential development. Your Lordships will have seen from the judgment below that those changes, section 15C, were made in response to concerns which had arisen in relation to the impact of the town and village green registration system on the planning system, and indeed the extent to which it was delaying development or preventing development coming forward. My Lords, it may be helpful just briefly to take your Lordship to the DEFRA guidance which summarises that point. Your Lords should have it in the same bundle at tab L, 2016 guidance to Commons registration authorities. My Lords, for present purposes, the relevant paragraph is paragraph 3 under the heading Introduction on page 1 or numbered page 1 of the document. In July 2011, the government published a consultation on the registration of new town and village greens due to increasing concern about the impact of such applications on the planning system. Government places great importance on the planning system to support efficiency, effectiveness and growth. This is partly why the government committed to delivering the Penfold Review recommendation to reduce the impact of Greens registration system on the planning system.
Well, what was proposed, is this right, in the consultation paper, was the twin approach of reducing the ability, restricting the ability to register a TVG on the one hand, and the creation of a new planning designation, local green space, on the other.
Yes.
Which was to attract the same protection as Greenbelt.
My Lord, yes.
And that is now, that local green space is now reflected in the NPPF.
My Lord, it is. So now local authorities can designate land as local green space.
Yeah. So the point of the changes, as I understand it, correct me if this is wrong, was to move local green spaces into the planning system rather than leaving them within the TVG registration system.
Well, my Lord, the way in which it has worked still allows the town and village green registration system to apply.
Yes.
So it has not moved entirely into that sphere.
No.
The two things operate in parallel, subject to the operation of section 15C.
Yeah.
But in terms of the recommendation, my Lord, your Lordship's absolutely right. Yes. So, and your Lordships, although it's set out there in fairly succinct form, your Lordships may know or indeed recall that the particular concern or examples of the particular concern would be a situation where a landowner applies for permission to develop land and that is a controversial application, and the local community then immediately puts in an application for registration as a village green, or a local authority with an emerging local plan, even at the draft stage, promotes an allocation of land for housing, and the local community reacts in exactly the same way. And, my Lord, there was genuine concern at the time that was being used largely as a device to kill or delay development, working on the basis that whether or not the application for registration ultimately succeeds, the mere delay and the uncertainty that is caused by processing the application of itself was likely to either at the very least delay development, if not deter potential developers from pursuing sites.
And I suppose the mere making of the application was itself sufficient to put a stop to the proposed development without any need for an injunction or cross-undertaking damages.
Indeed, my Lord, because a developer would be very wary of going ahead with a scheme in circumstances where he may subsequently discover that it's a village green that he's been building on. And that's what I mean about deterring. So while the threat is there, of a village green application succeeding, it's at the very least going to delay development. And if you have landowners who are taking land to the market, looking for potential developers, many developers may never even want to touch the project if there is a village green application there. I make that point, my lord, because you will appreciate that the particular instance, or those instances, are relatively specific. There is a clear identification of land through an allocation and a plan. You know exactly what land's being talked about. The community can see it, and it's because they see this piece of land is under threat that they respond by making the application for registration. There's a very clear correlation between the two. So, my lords, that's the relevant legislation. If I can deal as briefly as I can with the facts, the background in general terms is set out in paragraphs 4 to 25 of Mr. Elvin's judgment below. And my lords, much of that is relevant principally to ground 2, as was argued before him, and what may be Mr. Jones' cross-appeal, should we need to get there. My lords, for my purposes, it's enough for your lordships to know that the claim concerns an application to register land at Royal Wootton Bassett. Your lordships have a copy of that application in the first bundle at page 265, which in mine is Appendix A of tab 18. My lords, my lords, I take your lordships here principally to show you the site, and indeed
We've got a nice little picture of it at 277.
my lord, yes, but can I also, my learned friends has copies, I think, of a slightly better map of Royal Wootton Bassett, which comes from the development plan and actually shows your lordship the settlement boundary. And it seemed to both of us, it may be sensible for your lordship to have that. My lord, I'll come to the plan I've just handed up in a moment. The application itself, the plan associated with it, which has not copied particularly well, but your lordship will see, is at page 274.
Right, just pausing for a moment.
Mm-hmm.
Inset map 3, which you just handed us, is from the development.
This is, it is, my lord. It goes alongside the CP1, and well, it goes alongside the part of the development plan that your lordship. Well, in fact, it's inherited from the previous local plan, isn't it?
It goes to CP2.
It goes to CP2. It's
CP2.
It's not.
CP2.
Because I was looking at, we've got in the supplementary bundle at page 28,
Yes.
we have a map of Royal Wootton Bassett and the Cricklade community area, but it's not that one. It's a different map you just handed us.
That's right, my lord. The
Yeah.
plan we've handed in is from the development plan. In effect, as it was in the court below, but it got omitted. It is the development plan policy that in relation to CP2 and CP1 shows the settlement boundaries. This is the actual insert plan, which is certainly mentioned in the documents. It's part of the plan. It's the actual place that physically shows you. So that in this case, although you could, well, let's get into the arguments. This is actually a plan that has a line on.
No, I see that, but at the moment I just want to know where, so to speak, it should be cross-referred to in the development plan document.
My lord, I want to take you to the text of the development plan because, and I will remind myself where it is as I do that. Right. There is a specific reference to the fact that the plan which has CP1, CP2 did not amend the boundaries of, there were saved policies from an earlier plan, and the emerging core strategy is that then didn't change those, and I suspect that what we have here is therefore the line from the earlier plan, but I need to check exactly which document, but your lordship will see the cross-reference between the two in any event, because whichever document it comes from, these are the limits to built development which are referred to in CP2.
Right, and the notation "the land" is obviously not part of the official plan. Somebody's put that on for our convenience.
Yes, that's right.
So it is right on the boundary. I mean, that appears to be clear.
Well, my lord, it's certainly at the time it was right on the boundary. Your lordships will see, as I say, the photocopying at page 274 has not come out well.
Yeah.
But in the period since this plan was adopted, the triangle immediately to the east of the green site has been developed, and so I understand has the almost. If one were to continue that, the southernmost line across to the area which is hatched in purple, most of the area above that has since been developed, I think, as I understand it, for residential use. And one can see part of that both on the plan at 274 and indeed one of the other plans I'll take your lordship to in a moment. But originally it was a triangle of land, as your lordship says, on the edge, on the boundary of the settlement.
But now it's in the middle of a built-up area.
But now it's in the middle of a built-up area, yes.
My understanding, my lord, so far as the planning policies are concerned, they have remained the same. So the boundary hasn't changed in terms of the application of the policy, but built development has been allowed,
Yes.
for whatever the reasons are not in it,
Well, outside the settlement boundary.
outside the settlement boundary, which can happen. You have policies, but I haven't investigated the details. That's not my client's land.
No. So, Lord, you see where the site lies in relation to Wootton Bassett. I said there was a slightly clearer plan indicating some extent of the housing. If your lordships go to tab B, which is Appendix C of the committee report, which is where these documents are taken from, at page 277 and 278, 279, your lordship will see there are a series of photographs, but there's a plan alongside each to indicate where the photograph was taken from. And your lordships will see what I mean when I say that the land on the eastern boundary has since been developed for housing.
Yes.
It doesn't show your lordship the full extent of that, but it's quite clear, as my lord points out, that it's now within, may not be within the settlement boundary of Wootton Bassett, but it's certainly within the developed area of town. And my lords, if one goes back to the inset map 3, one will see that within Wootton Bassett there are, in addition to the significant areas of built development, your lordships will see large areas that are open. Some of those are parks, one of them at least is a cemetery, a number of them are associated with schools and their playing fields. And one can get some sense of which is which from the plan at 264, where SC and SEM are noted on some of those areas. My lord, nothing particular turns on precisely how they've been notified, but I do draw your lordship's attention to the fact that within that settlement boundary there are significant areas of open land at present. So, my lords, that's all I wished to say in relation to the application. I next need to take your lordships to the relevant policies of the development plan, which your lordships can put bundle 1 to one side for the moment and take up your lordships with the supplementary bundle, which tab 1 has the policies which are relevant for this appeal. They were the policies relied upon by then the claimant, now the respondent, and the basis for the judge's conclusion. My lord, it starts page 1, an introduction, a strategy focused on delivering stronger, more resilient communities. If your lordships turn to paragraph 1.3, we're told there are a number of key principles which underpin the strategy to help build more resilient communities, and then a series of bullet points, the first providing for the most sustainable pattern of development that minimises the need to travel, maximises the potential to use sustainable transport, One then has creating the right environment for economic growth, managing development to ensure jobs and the right infrastructure are delivered, working towards lowering Wiltshire's carbon footprint through appropriate location of development, protecting and planning for the enhancement of the natural, historic and built environments, including maintaining, enhancing and expanding Wiltshire's network of green infrastructure to support the health and well-being of communities, and then well-designed development and appropriate community-led planning policy documents. My Lords, can I then take you on in this to page 7, where there's a chapter headed Delivering the Vision, the Spatial Strategy for Wiltshire. Chapter 4, your Lordships will note at paragraph 4.3, the spatial strategy consists of 3 elements. A settlement strategy, which classifies settlements based on an understanding of their role and function. A delivery strategy, identifying the level of growth and how Wiltshire's settlements will develop in the most sustainable fashion. And then infrastructure requirements. Moving down, paragraph 4.6, the promotion of sustainable development. Spatial strategy sets the foundations for how sustainable development is defined and applied. Settlement strategy core policy 1 identifies the different tiers of settlements based on an understanding of the role and function of Wiltshire's settlements, how they interact with immediate communities and their wider hinterland. In doing so, the settlement strategy, coupled with the delivery strategy, seeks to define where development will be the most sustainable across Wiltshire's settlements. I might ask your Lordships particularly to underline that, where development will be the most sustainable across Wiltshire's settlements. One then has, at page 8, a heading Core Policy 1. This isn't yet the policy itself, it's the reason justification or the text that goes alongside the policy and amplifies it. 4.11, we're told the settlement strategy identifies 4 tiers of settlements, namely principal settlements, market towns, local service centres, large and small villages. We're told at 4.12 that the larger of those serve different strategic roles, which have been identified. The results of the classification are set out in CP1. And then settlement boundaries of the principal settlements, market towns, local service centres, as defined by the former district local plans, will be carried into this strategy and retained. My Lord, that was the reference that I had in mind when in terms of where this fits. These settlement boundaries will be reviewed as part of the Wiltshire housing site allocations and Chippenham site allocations DPDs, development plan documents, as set out in the Council's local development scheme, in order to ensure they are up to date and can adequately reflect changes which have happened since they were first established. And my Lord, that is the process by which presumably the subsequent development outside the boundary would now be brought within the boundary, and indeed there may be future allocations, further allocations of land. But certainly at present purposes, the further allocations DPD had not progressed to the point where it was the development plan, and therefore one is still with the plan at inset map 3 that your Lordship's seen. 4.14.
Well, don't we need to look at the last sentence of 4.13 as well?
Will also be the prerogative of the community to review settlement boundaries through a neighbourhood plan, my Lord, yes.
Yeah.
Yes.
And that has to be substantially in conformity with the development plan.
My Lord, yes.
So it could tinker with the boundaries, for instance, or it could allocate some piece of land as local green space.
My Lord, it could. There will be questions of judgment in terms of whether the size of that was so large that it became strategic and was therefore no longer in conformity, but certainly to the extent that this document recognises the ability for the neighbourhood plan to identify such land. It couldn't be said that it would be contrary to it simply because it had said we would like to have 10 houses here or an allocation for that. Paragraph 4.14, the level of development at local service centres will be closely linked to their current and future role for providing for significant hinterland. And then 4.15 deals with the settlements identified as villages and provides guidance on the limited level of development there. Midway through 4.15, there's a sentence that begins, development outside the settlement boundary will be strictly controlled. Relaxation of the boundaries will only be supported where it's been formally reviewed through a subsequent DPD or a community-led neighbourhood plan. It goes back to your Lordship's point. And then 416, any existing settlement boundaries for small villages and other settlements not identified in settlement strategy will be removed. General presumption against development outside the defined limits of development of the principal settlements, market towns, local service centres and large villages. 417, proposals for improved local employment opportunities, housing growth over and above that, or new services and facilities will not be supported unless they arise through community-led planning documents such as neighbourhood plans endorsed by the local community in accord with the provision of this plan. Lord, but then one then comes to core policy 1 itself, the settlement strategy. It starts by saying it identifies the settlements where sustainable development will take place to improve the lives of all those who live and work in Wiltshire. The area strategies in Chapter 5 list the specific settlements falling within each category. Principal settlements, one sees Wiltshire's principal settlements, strategically important, the primary focus for development. They'll safeguard and enhance the strategic roles as employment and service centres, and the policy says they will provide significant levels of jobs and homes with supporting community facilities. And the principal settlements, Chippenham, Trowbridge, Salisbury. Market towns, of which Wootton Bassett is one, my lords. Outside the principal settlements, market towns are defined as settlements that have the ability to support sustainable patterns of living in Wiltshire through the current levels of facilities, services and employment. Market towns have the potential for significant development that will increase jobs and homes in each town in order to help sustain and, when necessary, enhance their services and promote better levels of self-containment and viable, sustainable communities. And then one sees similar a text in relation to local service centres, the smaller towns and the larger villages which serve a surrounding hinterland that have a level of facilities that provide the best opportunities outside the market towns for self-containment, and those will provide for modest levels of development in order to safeguard their role, deliver affordable housing. And then the large and the small villages, again, an explanation as to what that means, and guidance as to the level of development there. Development at large and small villages will be limited to that needed to help meet the housing needs of settlements and to improve employment opportunities, services and facilities. So your lordships will see there the overall structure of CP1, the hierarchy that is created and the specific guidance that is given in relation to each level of the hierarchy as to the overall kind or scale of development which it's anticipated should be directed towards settlements in the interests of sustainability, making sure that people have access to jobs, services, public transport and don't need to get in a car in order to drive to access those things more than necessary. My lords, we then move to core policy 2, the delivery strategy, and again begins with the explanatory text. The delivery strategy 418 tells us, recognises that in some settlements jobs have not necessarily been delivered alongside homes, seeks to strengthen communities by allowing appropriate growth to provide for the most sustainable pattern of development, reducing the need to travel, help to redress the imbalance between jobs and homes. 419, the underlying principles of the strategy to ensure that communities have a better balance of jobs, services, facilities and homes, underlines the focus of the strategy to support the growth of principal settlements, which provides the greatest opportunities to deliver self-containment and potential to generate job growth. And then 420, the strategic housing requirements set out in order to support the most sustainable pattern of growth in line with the principles defined in Core Policy 1. Indicative requirements are provided for each principal settlement, market town and by community area. And those allow a flexible approach which will allow the council, through the preparation of the Allocations DPD and local communities' neighbourhood plans, to respond positively without being inhibited by an overly prescriptive or rigid approach which would otherwise prevent sustainable development proposals. One then has a key diagram, or two key diagrams, my lords. If you turn, or would turn please, to page 15. 424, in planning for new homes, a number of sources have been identified to ensure a continuous supply of housing. Those are strategic allocations, retained local plan allocations, existing commitments. Those will be sites that already have a permission in place. regeneration projects, business expansion plans, sites identified through DPDs and neighbourhood plans, and then windfall sites in accordance with the delivery strategy. And the reference to windfall sites, my lord, is a recognition that the fact that however much a local authority investigates land that's available for development, there will always be people who come up with sites that hadn't been foreseen. A garage owner wishes to sell a garage and says, can I put houses on it instead? And those are the windfalls referred to there. And there's also, we're told at 425, an exception policy which seeks to respond to local circumstances. And 425 sets out, there are specific policies in the plan which deal with each of those: additional employment land, military establishments, tourism, exception sites, specialist accommodation, supporting rural life. Now, your lordships don't have those policies, but in different ways and to differing extents, each of those policies recognises circumstances in which development of those particular categories will be acceptable outside the limits to built development. Some of them seek to focus it, for example, on the edge of existing settlements. Others set more criteria as to the circumstances in which will be allowed. But they all recognise that developments of that sort may be appropriate in the countryside.
Right.
426, in order to direct development at a strategic level to the most suitable, sustainable locations and at appropriate times, the area strategies contain an indicative housing requirement, and your lordship then sees the indicative requirement. There are two levels, my lord, the black and the white. There's a level for town and a level for the remainder. And my lord, that goes back to the point which arose earlier, that effectively settlements also have as it were, a hinterland identified around them, beyond the settlement boundary, but a recognition that there may be, within a wider area, a contribution to be made. Your lordships will see in each of the cases the vast majority of the provision that's to be made will be within the main settlement or itself. And then 427, core strategy allocates sites and broad locations for growth that are strategically important. Additional sites will also be identified through the DPDs to ensure the delivery of housing across the plan period. 429 at page 19, area strategies identify specific issues that must be considered when planning for these areas, and these should be taken into account when assessments are carried out to identify specific sites. Core Policy 2 provides a framework for parish and town councils to lead with neighbourhood plans. Councils preparing a housing sites allocation DPD to ensure sufficient choice and supply of sites. And then 430, the disaggregation to community areas set out above is not intended to be so prescriptive as to be inflexible and potentially ineffective in delivering the identified level of housing, clarifies the Council's intentions in the knowledge of likely constraints in terms of market realism, infrastructure and environmental capacity, a strategic context for the preparation of the housing sites DPD in order to plan for appropriate infrastructure provision. Well, Lords, I can then turn to policy CP2, which is at page 21. And my Lord, the policy comes, in essence, in three parts. The first is the overall delivery strategy, which refers to the minimum housing requirement and identifies the particular, what are called housing market areas within Wiltshire, amongst which that overall level of need will be allocated. We're told it be delivered in a sustainable pattern in a way that prioritises the release of employment land and reuse of previously developed land to limit the need for development on greenfield sites. My Lord, one then comes after the overall explanation of the 42,000 and where that will be developed, to the heading within the defined limits of development. Within the limits of development, as defined on the policies map, there is a presumption in favour of sustainable development of the principal settlements, market towns, local service centres and large villages.
Sorry, just before we go on, do you place any particular emphasis on the final paragraph just before the subheading within the defined limits? It says sites for development in line with the area strategies will be identified through subsequent site allocation DPDs. I mean, on one view, that might perhaps be a pointer to a greater degree of particularity, which is envisaged as happening at a subsequent stage. and that might be argued to be something that ties in more easily with the statutory language that we have to construe. Just crossed my mind as a
My Lord, certainly your Lordships will have seen in the judgment below discussion of the extent to which policy CP2 is a development management policy.
Yes.
And as I'm sure your Lordships appreciate, that's a reference to, is it intended to be used in determining planning applications? And the answer to that question in part is yes, but also there are parts of the policy which are directed not at determining individual planning applications, but at the development of later documents in the suite of development plans, such as the site allocations document. Now, my Lord, the sentence to which your Lordship takes me is plainly directed at setting out a framework within which the later development plan documents, such as a site allocations DPD, would be brought forward. It's indicated as guiding that. But, my Lord, I can't and don't say that that is the only way in which the policy envisages that housing may come forward. Your Lordship's seen the reference, for example, to windfall sites.
Yes, indeed. Yeah.
And as Mr. Morgan accepted below and I accept today, certainly there are parts of this policy which are patently intended to be they may be relevant to the preparation of future plans, but they are also relevant at a development control level. And indeed, within the limits to development, the presumption in favour of sustainable development, that could be relevant in terms of bringing forward sites under a site allocations DPD, but it would also be relevant in considering an application for planning permission. I readily accept that. And indeed, if one looks at the counterpart to that, at the top of page 22, outside the defined limits to development, other than in circumstances as permitted by other policies within this plan, identified in paragraph 425, development will not be permitted outside the limits of development as defined on the policy's map. And the way in which that is worded is quite plainly directed at a determination of an application for permission. Development will not be permitted. I do make the point, my Lords, and it's something I come back to in my submissions a little later, that although it indicates that development generally will not be permitted outside the limits, even that part is not exclusive. It does recognise that development of some types, of the types identified in paragraph 425, may be acceptable, even though they are in the countryside, and that may have some bearing in terms of an argument about what Section 15C and the schedule mean when they talk about potential development. So, my Lord, that's the second part of the policy. There's a reference then also to what would be allowed at the small villages and the limits that are there, and then one has effectively the third part, which are the strategic allocations, and there are a number of sites that are identified there. My Lord, that text would be read together with a series of plans which one has in the same core strategy. Your Lordships have an example of that at page 31 of the bundle in relation to Fuggleston Red, but a series of plans which show the boundaries of those sites. And your Lordships will see that the allocation not only identifies the particular sites, but it also gives a clear indication as to precisely what sort of development will be expected on those sites. So,
looking at inset map 3, which you gave us this morning,
my Lord, yes.
there is a light brown square within Royal Wootton Bassett, marked H2.
Yes.
Which the legend tells us is a residential allocation.
My Lord, yes.
But that's not, is it in CP2? Or if it is, I can't see it.
There's no reference to anything in Wootton Bassett.
No, so
well, my Lord, no. And I think that probably flows from the fact that this comes from an earlier plan.
We mean it's already been developed by the time.
Yes, it will have been
by
taken.
the time we get to this.
But whether or not it will have been developed, the allocation may have been carried over. It's certainly been developed. It's certainly been developed since.
Right.
But it was an allocation. But it's an allocation from, I believe, and I'll stand to be corrected, an earlier plan, not from this core strategy. This core strategy, certainly in CP2, what one has is strategic allocations. Now, and my lord, as far as the strategic allocations are concerned, I would have no quarrel with the argument that Central Car Park, Salisbury, Churchfields and Engine Sheds, those have been identified for potential development. That in my submission will be quite clear.
Well, if I can have, our understanding, and Maloney Friend's quite right, this is a plan carried forward from the previous plan. So whilst the settlement boundary is carried forward, some of the policy notations
May not
are those from the previous plan, so they could be apt to mislead in terms of indicating allocations. The things that, as I understand, remain, for example, are the indication of the area of the conservation area, the boundary settlements, and those are what have been carried over. Those are what have been carried over by the plan, but not things, for example, BD1 employment.
No.
It may or may not be, but you'd need to look at the new plan for that. So,
As far as H2 is concerned, either that's lost its allocation or it's been developed or whatever.
or not.
Yeah.
Yes, my lord, certainly when I
Yes.
went on, I'm at risk of giving evidence when I Google Earth or satellite or whatever it was, there was an indication of a housing estate on that part of the land. But
It's a fair assumption that hopefully for the Maloney Friends clients that their allocations are coming forward, but
we would hope so.
but not always the case.
But the point is, my lord, it's an historic allocation
I follow.
and not part of this core strategy. Good. So yes, so my lord, so those are in essence the three parts of policy. My lord, if I just check my notes.
Do we need to look at core policy 19?
Your Lordship, we do. Just before we go there, I wanted to make sure there's nothing. No, that was what I wanted to take your Lordship to in terms of CP21. CP1, CP2 are the policies that are relied upon by the claimant in this case, or the claimant as was. But your Lordship is quite right. There is particular guidance for the different areas within Wiltshire. And your Lordships have the guidance in relation to Wootton Bassett at page 24. Spatial information and context, we're told, contains the historic market towns of Wootton Bassett and Cricklade. At 598A, description of Wootton Bassett, largest town within the community area. Its location from Swindon. It's been identified as a location for new strategic employment growth to help out commuting, as the country has a dormitory role. And similar background provided in relation to the MOD site, Cricklade, reference to housing growth in the main settlements, and then 5102 at page 25, specific issues to be addressed in planning for Royal Wootton Bassett and Cricklade include non-strategic growth should be brought forward in accordance with core policies 1 and 2 and phased through the plan period to deliver homes in a balanced manner that will enable infrastructure issues to be addressed. So a clear recognition that just because it's not a strategic allocation, that the strategic allocations aren't the sum total of what will occur in Wootton Bassett. And then at page 26, a mix of development alongside housing is also important. And then Royal Wootton Bassett currently loses main food and shopping trips to neighbouring towns. No guarantee, no quantitative need for additional convenience retail in the town. Additional floor space may be appropriate, and there is a limited capacity for up to 400 square metres of comparison retail in the town. So particular examples given of the sort of development that will be needed in Wootton Bassett, and a number of bullet points, my lords, dealing with different issues, some specific to Wootton Bassett, some more relevant to the wider community area. At the top of page 27, your lordship will see the first new bullet point. Further work is needed to identify how improvements to recreational facilities in the community area can be delivered, and reference to particular sports facilities included within that. Paragraph 5103 comes under the heading, how will the Royal Wootton Bassett and Cricklade community area change by 2026? We're told Wootton Bassett will continue as the main service centre. Retail offer will have been enhanced. The town will have an appropriate level of facilities for its size, with a hub for sports at Ballard's Ash. people with the community area will have access to a range of jobs within the town. So then, along with the Rivers of Ray, the restored and enhanced Cricklade Countryway will provide social, environmental and economic assets. The policy itself, your lordships have at page 29. Development should be in accordance with the settlement strategy. Wootton Bassett as the market town, local service centre Cricklade.
Would we get any help from a colour version of the plan on page 28? So I see that it has residential allocation as one of its categories. I'm afraid I can't translate that onto a black and white copy that we've got.
My lord, at the moment I'm struggling to find, on mine the residential allocation is a flesh colour and I'm struggling to see a flesh colour on the plan. It may be the scale at which we have it. For my purposes, my lord, no, I don't draw anything from that. So going back, my lord, to the policy, CP19, a reference to the level of new employment land that would be provided, the number of homes that would be provided, and at the bottom of the page, development proposals will need to demonstrate how the relevant issues and considerations listed in paragraph 5.102 will be addressed. So, my lord, that's what is said in relation to Wootton Bassett in particular. So, my lord, those are the policies of the plan. The last point that I wanted to make by way of just the factual background is to show your lordship briefly how the question of trigger events was dealt with by the council. And my lords, for that we need to go back in bundle 1 to the first part of tab 18. My lords, this is the committee report dealing with the application, and your lordships will know that one of the objections raised, indeed the main objection raised by the respondent to registration, was that there had been a trigger event, and your lordships will have seen a copy of an opinion from my learned friend Mr. Jones, Queen's Counsel, was sent to the council for consideration. My lords, if you go to page 258 of the main report, your lordships will see, starting at paragraph 19, a reference to that argument. The landowners also object on the ground there's a planning trigger event, and a quotation set out from the point made. Paragraph 20, the question of planning and trigger and terminating events arises from the Growth and Infrastructure Act. Explanation given there of what the Act provides. And then paragraph 21, accordingly, on receipt of the application, the council in its capacity as registration authority wrote to the planning authorities on the 15th of April, including a list of trigger and terminating events requesting details.
That's itself, is it?
Well, it would be a different
hat.
Yes, as presumably as Minerals Planning Authority and also as Local Planning Authority. It's unitary, yes, so it will have the minerals functions.
And local planning, it's a unitary authority.
Yes.
It's all one.
Yes. Yeah. So, but yes, in essence, it asks a different division of itself, the question. Yeah.
So TVG is not dealt with by the planners within Wiltshire?
No, the registration authority, it's a separate function within the council.
Right. So different officers?
Different officers, right. Indeed, yes. And then paragraph 22, Council's registration authority must rely upon the responses given by the planning authorities, and then a quotation from the advice given by the head of spatial planning, and the conclusion of paragraph 23, therefore the right to apply has not been extinguished. The registration authority must continue to determine the town village green application based on the available evidence, which is not disputed by the objectors. And my lord, that report, as your lordships may have seen, was available for consultation before the meeting. On sight of it, the respondent sent a further letter and an updated opinion from Mr. Jones, essentially reiterating the point that there had been a trigger event. And your lordships finally, for my purposes, have the council's comments on that in an addendum or an agenda supplement report. It starts at page 228, but the relevant paragraph or parts are at 229 under the heading Trigger Events, which referring to the objections, say that the report's not deeply flawed in the advice that it gave. The planning authorities have been consulted, advised there are no trigger events. There's reference to the DEFRA guidance. The fact that planning officers are believed to have sought their own advice. The purpose of the settlement strategy is to provide a framework and identify areas of, as is grown, I think it should be growth, where development will be focused in order to provide the basis for future decision on potential development in identified settlements, including market towns and community areas. Without more, the settlement hierarchy cannot be considered to undertake the specific task to identify land for development. The core strategy is therefore not aimed at specific sites without a neighbourhood plan or development plan, both of which would be site-specific. And there's a reference to the fact that
that's the issue.
That is the issue, yes, that is the issue. And, my Lord, in many respects, I take your Lordships here to show your Lordship that it was grappled with by the Council, but in essence, it wouldn't matter what the Council had said, or indeed whether it had or had not grappled with it. The answer is either right or wrong, it's a matter of law. But your Lordships will see the penultimate paragraph, core strategy doesn't identify the land, therefore cannot be a valid trigger event under the trigger event identified by the landowner, being a development plan document which identifies the land for potential development. And as your Lordship says, that is the key issue. So, my Lord, with that, by way of background, can I then turn to my submissions? And as I indicated at the outset, I propose to start not with the judgment below, but with my submissions on what the proper approach is, and then I'll pick up the way in which it was dealt with by the judge. My Lords, I start from the point, and I don't apologise from approaching this initially from an argument of consequences. I know ultimately words mean what they words mean, and if they have unfortunate effects, then so be it. But I do start from the point that if one looks at the judgment and the fact that it is anchored in policies CP1 and CP2, and your Lordships have already seen CP2, settlement boundaries apply for principal towns, market towns, the larger and the smaller villages, everything except the very lowest level of urban area within Wiltshire. And if the judgment is right in relation to what it says about the impact of drawing a line, a settlement boundary around those areas, around Wootton Bassett, in my submission it's quite clear that that must apply to all the settlements for which there is a settlement boundary in Wiltshire. And my Lords, given that, as I've already indicated to your Lordship and shown your Lordship by reference to section 15, registration as a village green requires a neighbourhood or a locality with a significant number of inhabitants. In my submission, if it is right that anybody within a settlement boundary can no longer apply for a registration, that's a very, very significant incursion on the right to apply. It would effectively mean that the right to seek registration would be removed from the vast majority of the population of Wiltshire simply because they live within an urban area. And I do say at the outset that that would be a surprising result. I say at the outset also in my submission that it would be disproportionate given the nature of the mischief that the Act was intended to address, because it would remove the right to apply over areas of land within urban areas, even though there was no risk that they would ever be developed. There was no suggestion by a developer or by a local authority that they should be brought forward for development. And my Lords, in my submission, that's very, very different from the issues which led to section 15C, the fact that a developer makes an application and is instantly confronted by a town and village green registration application. As I say, it would apply to land over which there was no prospect or no threat of development, and that in itself would be surprising. My Lords, in terms of then whether that result is borne out or required by the legislation, I go back to the point that when Schedule 1A talks about a development plan which identifies the land for potential development, the land clearly in my submission means the land which is the subject of the application for registration. The plan must identify that particular land, and that's important. Because it leads us to the question, well, what then does it mean to identify that land? My Lords, in that respect, it's common ground that there's no statutory definition in either the Commons Act or indeed anywhere else that assists us. And one is therefore left with the ordinary meaning of the word. And in my submission, my Lord, it's inherent in the ordinary meaning of identify that there is a degree of specificity and certainty which leaves little or no room for doubt as to what it is that has been identified. My Lords, in that regard, I take your Lordships to and rely upon the judgment of Mr. Justice Lindblom, as he then was in the West Kensington estate case, which, if your Lordships have the bundle of authorities, should be at tab F. Now, your Lordships will see from the introductory paragraphs the facts of this case are very different. It's not a town and village green case. It concerns a challenge to a supplementary planning document for an opportunity area at Earl's Court and West Kensington. The reason why the concept of identification was in issue is because of the way in which the regulations that were relevant in that case, Town and Country Planning Local Development Regulations, use the word. And if your Lordships go to paragraph 15 of the judgment, your Lordships will see Regulation 6 of those regulations set out. Regulation 6.4 provides a document of the description in paragraph 2a is referred to in the following provisions as an area action plan. Paragraph 2, the description of other documents prescribed for other purposes, and the description given in 2a is, and then from the quotation, a list of documents, and the second is a document which identifies that area as an area of significant change or special conservation. So, my Lord, different statutory phrasing, but still the notion of something identifying, in this case, an area, in our case, the land. And if your Lordships then turn in the judgment to paragraph 54, your Lordship will see what the judge had to say about.
But the point in the case, as I understand it, was whether the area had already been identified by the London plan, or whether it was only identified in some supplementary planning document which hadn't gone through, or said not to have gone through the right process.
My Lord, that is right, and one of the points, points of argument, and one of the things on which the judgment turns is does identification does this have to be the first document? If it's already been identified somewhere and a later document takes that up and runs with it, can the later document be said to be identifying? And answer no, because the identification has already occurred. And that's why, my Lords, I recognise from the outset that factually it's a very different case, but nonetheless.
So the identification that Mr. Justice Lindblom said had taken place is, as I understand it, what we find in paragraph 22. That is identification.
Sorry, paragraph 22 of
his judgment.
My Lord.
He says this is what the London plan says.
Yes. Yes.
That he says that's identification of the area.
And certainly, my Lord, the London plan has opportunity areas and it draws a line around them.
Yeah.
So, but my Lord, nonetheless, the judgment does actually say something about how the word identifies should be interpreted. And below, the Deputy Judge considered that those comments were applicable in the present case, and I respectfully adopt that, although I differ from learned judges to how that, or what the application leads you to. My Lords, at paragraph 54, Mr. Justice Lindblom, as he then was, refers to the submissions of Mr. Harris, Mr. Elvin, and Mr. Kapkowski. The concept of identifying an area as one of change means establishing the principle of such change in a particular defined area. Once the principle is established, the identification is complete, and that's your Lordship's point about which is the first document to do it. If a document is to be an area action plan, it must be the document that achieves this identification, must make what Mr. Elvin referred to as the primary identification. And then the sense of the word identifies in Regulation 62A2 is plainly the ordinary English meaning of the transitive verb to identify, namely to establish the identity of, establish who or what a given person or thing is, to recognise, and that's a reference to the shorter Oxford English Dictionary. To construe the word identifies in Regulation 62A as if it means confirms the identification, will be to rob it of its true sense. So, very different context, I recognise that, my lord, but for present purposes, what I draw on and what was used below is the Oxford English Dictionary definition in terms of what identify means, to establish the identity of, to establish who or what a given person or thing is, to recognise. And I do place weight on that, my lords. Firstly, in terms of establishing what the land is, and secondly, in terms of identifying that it is for potential development. And when it says establish, in my submission, that means it needs to establish the principle that development on the land is acceptable. And my lords, in that context, in my submission, one does not establish who or what a thing is merely by establishing that it's within some wider category or area. If your lordships will forgive me what may be a slightly fanciful example, if I'm shown 100 photographs of Queen's Counsel, 50 of whom are robed for court and one of whom is Mr. Jones, I don't identify Mr. Jones by saying he's one of the ones wearing a wig, nor would I identify him by isolating 10 of the 100 photographs and saying to your lordships, well, he's one of the ones in the 10. I identify him by pointing to him specifically. The other answers, he's got a wig on or he's one of those 10, may narrow the field, but they don't identify Mr. Jones. And in my submission, my lord, the same principle applies to the concept of identifying land for potential development in terms of section 15C and the schedule. In my submission, for a plan to identify land for potential development, it's not enough that it narrows the field. It's not enough that it steers development generally towards an area which contains the land. In my submission, a plan doesn't identify land unless it is specific, and that identification itself answers the question whether the principle of development on that area is acceptable. Now, my lords...
Now, is that a change from your skeleton argument? Because I thought the skeleton argument accepted that it could be part of a wider area.
My lord, it may... I recognise that it can be a part of a wider area, but the point is that the whatever it is that identifies the wide area must establish the principle of the development.
Right. So it's not so much the identification of the particular parcel that you're concerned with, but the identification of the acceptability of development.
Yes, and within that, there must be, in my submission, a recognition that the development on the land is acceptable. I'll give your lordship an example. I don't know whether it is the case in Wiltshire or no, but your lordship's seen CP2, which has a settlement boundary. There are many local authorities which will have, will designate areas as open space or recreation ground or local green space.
Yeah.
And they will have a specific policy in the plan which says the loss of open space, the loss of green space, the loss of sports fields will not be permitted. Now, many of those areas will be within the settlement boundary because sports pitches often are. If one were then to ask, in a situation where you've got a settlement boundary, CP2, but a particular policy that says you cannot develop this piece of land, would it logically be said, could it sensibly be said that that land was identified for potential development when you have a policy which specifically says that it's not? And the answer to that question in my submission is patently no. Now, I'm sure my learned friend will say, and he's quite right, that the site in this case is not subject of any such policy. I recognise that. But in my submission, it's not an answer to my point. because my learned friend's case and the judgment below is dependent on the fact that CP1 and CP2 of themselves provide the answer to the question, is the land identified? And as soon as one recognises or accepts that there could be a policy cut out from that within another part of the plan, one recognises that CP1, CP2 are not a complete answer to the question. One has to go beyond those policies to find out where the land has been identified. And my lords, the one thing in my submission which the drafters of paragraph 4 of Schedule 1A could not possibly have intended is that when deciding or when asking whether land has been identified for development, a registration authority should have to put itself in the shoes of the local planning authority, go through the entirety of the local plan and work out whether or not planning permission might be granted for an entirely hypothetical and undefined development. It's not an exercise which it would be appropriate for a registration authority to do. It's not an exercise which the authority could do unless it knew what manner of development was being proposed. And it's why I say the plan, the policy in question, needs to indicate quite clearly whether the principle is accepted. And so I come, my lord, with that overarching submission to the way in which CP1 and CP2 are phrased. And I apologise for taking your lordships back there, but I think it's probably, you can find what I've done with them. Easier to make the submission with the policies alongside. If your lordships go back to the supplementary bundle, tab 1, core policy 1, my lords, is at page 10. And your lordships will see that what it tells us is that development will take place within the settlements. Well, my lord, the reasons for that, your lordship's already seen. The settlements are where services, public facilities, public transport are. That is where development should be directed at an overall strategic level. But, my lord, it does not follow, in my submission, from the fact that it is desirable to place the bulk of development in urban areas such as principal settlements and market towns, that every square inch of land within those market towns and principal settlements is identified for development. That's patently not what was intended. If one went, for example, to look at the playing fields that your lordship's seen in Wootton Bassett.
Sorry, when you say plainly not what was intended, are you now speaking of Parliament in enacting Section 15C and Schedule 1A, or are you speaking of those who drafted the local plan?
Well, my lord, well, at the moment, my lord, I'm asking what is it that CP1 is seeking to do? What is it that CP1 is seeking to do? And I readily accept that CP1 is seeking to steer development at particular levels of or scale to different places within the district.
Yeah, ultimately, our focus has to be on the parliamentary language, doesn't it?
My lord, it does, but what the Act tells us is, does the development plan identify the land? So at that point, one has to go to the development plan and ask what it is that the development plan is doing. Yeah. And that's the submission that I make to lordships about CP1. If one looks at CP1, and look, the words that we're focused on, understandably, because we are dealing with a market town, but the words that we're focused on in this case are those one sees under the heading market towns at page 11. And in particular, the second paragraph there, market towns have the potential for significant development. And it's one of those coincidences, if one likes, that potential for significant development is not a million miles away from potential for development, which is potential development, which is the phrase or the wording in the section. But well, just because similar words are used, one should not leap to the conclusion that that is what this policy is about, because one has to understand, in my submission, that that reference to market towns, it's part of a hierarchy. One goes back to principal settlements. The comparator for potential for significant development for principal settlements is they will provide significant levels of jobs. The comparator for local services, they will provide for modest levels of development. The comparator for your large and small villages is that development will be limited to that which is needed. This is not, in my submission, a policy which is identifying land within settlements as appropriate for development. It is providing a broad strategic steer as to where, in general terms, development should be directed and at what level that direction should take place.
So
But
really what you're saying is that market towns is not specific enough to identify the land. Is that really what it comes to?
Well, my lord, market towns, there is a list of market towns,
yeah,
and each market town has a settlement boundary drawn around it. I can't say that in either respect it's imprecise. My point is, what is this policy doing?
Yeah.
It's referring to a market town, but is it identifying land within the market town for potential development? And my answer to that, my lords, is no, it's not. It's telling you that in the interests of making sure people can walk to the shops and to schools, towns are the places where ideally you would put the majority of development, but it does not follow from that that everywhere within the urban boundary of a market town, or everywhere within the urban boundary of Salisbury, is thereby identified for potential development. It simply does not follow. And it would, as I said, if it did follow, it would mean that every playing field, every cemetery, every conservation area, the setting of every listed building of Wootton Bassett was identified for potential development. And that simply does not make sense. It cannot, in my submission, logically be what this policy is intending to do. And in that sense, my lord, if one is asking what it's intending to do, it's appropriate to ask, is this policy identifying land for potential development? And in my submission, it's not. It's strategic. It's about where, in global terms, growth should go. But it's not, in any sense, intended to say that once you're within a settlement boundary, there's some sort of free-for-all, and every part of that area is identified. Oh, Lord, let me just check, because right. So, my lords, that's what I say about CP1. I appreciate that the way my learned friend puts the case is CP1 or CP2 on their own are enough to get him home. One also needs to look at the two together. Can I then turn to CP2? Because in my submission, the points I've made about CP1, or the conclusion I draw from CP1, isn't materially altered by consideration of what CP2 adds. Your Lordships have CP2, page 21. I've already drawn attention to the fact that it's a policy that comes in three parts. For present purposes, it's the middle part that is relevant. Within the limits of development, there is a presumption in favour of sustainable development of the principal settlements. But, my lords, overall, this is a policy, the delivery strategy, which is designed again, as CP1 directs growth within the area according to the hierarchy of the settlements. If one is looking at this part of CP2, one has to read what is said in relation to land within the settlement boundaries alongside what is said about land outside the limits to built development and the much more restrictive approach that is taken in that regard. And again, my lords, I ask you to put what is said there back in the context of what your lordships have seen from the associated text, the explanatory memorandum, the justification for the policies, about what they are seeking to do. That this is about planning in a sustainable way which maximises or minimises the need for people to get in their cars and drive, maximises the benefits for people of being able to walk to shops and schools and jobs, or to get on a bus or on a train and do it. Because, my lords, in that context, what you have here is a policy, in essence, which separates out the urban areas where you have all those sustainable things, and the countryside where, by and large, you do not, or certainly it's a lot harder to find them. And it's a simple but crude way of saying, in general terms, the countryside is a bad place to develop. There are exceptions to that, and I have a point to make about that in due course. But again, my lord, I come back to the fact, the same submission in essence that I made in relation to CP1, that this is a policy which operates at a strategic level. It is a broad indication of where development should be directed, but it is not an acceptance of the principle of development on any particular piece of land. And I mean, your lordship's...
Say that last bit again. It's not an acceptance
of the principle of development on any particular piece of land. And that, my lord, goes back to what I said about what was necessary in order to identify the degree of certainty that one needs to have in order to identify something. And I do say in my submission, identification in this case must mean that the principle of development is established.
Yeah.
You wouldn't identify land by, I'll come in a moment to whether or not you'd ever have a development plan policy which says, well, you could or you couldn't have development here. But my lord, as I say, in my submission, it needs to establish the principle. And my lord, critically, what the local plan is doing here is not unusual. Almost every local planning authority up and down the country, certainly any local authority that has a mix of urban areas and rural areas, will have, they may call it a limit to build development, they may call it a settlement boundary, they may call it a village envelope. There are a dozen different names for it. But the idea that you draw a line around your urban areas is widespread. Almost every authority with rural areas will have a policy of this sort. And the purpose of that policy is to delineate between the countryside and the urban areas, because in overall terms, where is the better place to be locating development? In general terms, it's in the urban areas, because that's where you have the access to facilities and so on that I've referred to. But my lord, again, it does not flow from that by identifying an urban area, putting a line around it, you are saying that there is some kind of free-for-all for land that's within it. Now, the policies which local authorities will have may vary in the wording that they used. It will frequently be the case that the policy will say outside the limits to build development permission will not be allowed unless. What it says inside may vary from case to case, but the implication is always the same. Inside the settlement boundary, in overall terms, because you will have access to facilities, this is where development should be directed. But I go back to the point I've made before, that doesn't mean that everywhere within it is acceptable.
There are two different ways of looking at this,
Yeah.
different points, if you like. Entirely accept that the fact that there is a policy like CP1, CP2, with a drawn settlement boundary does not result in what you call a free-for-all. Of course not.
No.
Not least because, as you rightly say, there will be other policies which prevent development on particular parcels of land. There might be listed buildings, there might be bits of green belt, there might be local open spaces or whatever it happens to be. So the spectre of a planning free-for-all is, in a way, not something that really matters.
Well, my lord,
What might be said, and you also say, and there's force in this, that Commons Registration Authority should not be required to decide for itself about the likelihood of planning permission being granted or not. But the drawing of a settlement boundary does at least provide, if there's a policy like CP1, CP2, does give a Commons Registration Authority a clear-cut means of deciding whether or not a TVG should be registered, because the effect of the TVG is that there's no prospect of development ever. Whereas even if it were to be a local green space, there might be ways of replacing it or mitigating its loss or something like that. Or there might be exceptional circumstances, as there is sometimes in Greenbelt, which would permit development.
Well, my lord, can I go back to something your lordship said earlier, which is, you know, the spectre of a free-for-all is not what matters, because there will be other constraining policies which indicate that development may not be acceptable. I ask your lordship just to think for a moment about the implications of that. First of all, I go back to the point that I made. This case, my learned friend's argument, the judgment below, hangs on the fact that CP1, CP2 of themselves provide you with an answer to the question, is the land identified? And if it's right, and in respect to your lordship, it is entirely right, there will be other policies which quite clearly indicate that within certain areas, many of which will have their own lines drawn around them because they're a site of nature conservation value or whatever it may be, where development will not be permitted. If that's right, then it is quite clear in my submission that CP1, CP2 do not answer the question. So the basic premise of the judgment below falls away. You can only answer the question by going beyond. But, my lord, there's an added point, because if your lordship is right that actually there isn't the dreadful spectre of a free-for-all, because in practice permission would never be given to develop a sports field or an area of public of open space or local green space, if in practice that would never happen, then what is the rationale for saying it's impossible to apply for village green status for that land simply because it's within the settlement boundary? And I go back to the mischief. The mischief that is aimed at here was the abuse of town and village green registration to prevent development which might otherwise happen. Your lordship posits a situation in which that development would never happen, therefore there is no possibility of abuse, and yet village green registration is still not possible, simply because it happens to be within an urban area, which could be, most of London is within an urban boundary. The idea that you could not have a village green registration anywhere within urban London, I've mentioned Salisbury because it comes from this plan, but in my submission the same point applies, because the same basic distinction between urban areas and open countryside is one drawn in almost every plan.
Could one perhaps sharpen the point by hypothesizing a case where the area over which a village green is thought to be established is also a site of special scientific interest, which is not impossible. I mean,
it's not, and indeed, my lord, that there are, yes, it's not impossible.
I mean, it might be a roost for a protected species of bat, or contain a pond with greater crested newts in it, or have a rare plant growing. You know, that kind of thing is not impossible. It wouldn't apply to the patch of land we're dealing with here, I'm sure. Or at least I'm pretty sure.
And Lord, let's take your lordship's triple SI point. Not every local plan or core strategy does it, but most plans will have a policy which indicates that where you've got a triple SI development, I mean, it may be possible in extremis, but it would be a very, very long or big ask to get permission to develop there. So in those circumstances, you have a clear policy which says no in relation to that. If one goes back to the question that is posed in paragraph 4, is that land identified for potential development? CP1, CP2 tell you the answer to that is yes. And that is a complete answer to whatever else the development plan may say. Yet you have a policy which says, in this case, the answer is no. And it simply doesn't stack up in my submission to say that in a case such as that, the development plan identifies that land for potential development. It has a policy which says it's not identified for development. Indeed, it's specifically identified for protection for some other purpose.
I mean, is it perhaps another way of putting it, of your case, is to say that, yes, the settlement boundary does, in a sense, identify the land, but it does so at too high a level of generality, because it doesn't allow for these further considerations, which...
Well, my lord, I would, it could certainly be put that way, and I wouldn't shrink from putting it that way, but I would ally it with the point that what is the purpose? What is the actual purpose? Is it to say everything within the settlement boundary is identified for development? The answer to that is no. Now, it may well be because it's not at a sufficient level of specificity. That may be part of the explanation for it. But I go back to this is about purpose. What are CP1, CP2 trying to do? Although they have a development management role, they are strategic policies about globally what is a good place to put development and what is a bad place. And it's perfectly possible to say, well, globally, we should be putting development in existing urban areas. But that does not identify or mean that the whole of that urban area should be up for grabs. It simply doesn't flow.
I think we've got that point.
Yeah, indeed, my lord. And I'm going to try and make sure I don't repeat it any more than necessary. Yes. Well, Lord, can I just, in that regard, and it may well be that I'm anticipating an argument that may be put, I did touch on the fact that if one looks at CP2, although it's quite clear that it is extremely discouraging about development outside the limits to build development, it's not a policy which prohibits it. It's a policy which specifically recognises that in certain circumstances, development outside the limits to build development will be permitted if you fall within any of the paragraph 4.25 examples. And well, that has a particular bearing on the argument that was raised by the judge below in terms of the breadth of the word potential and what my learned friend says, because there's nothing in the paragraph 4 which says it has to be identified for all kinds of development. It's enough that it's identified for development. So if the first part, the within the limits to build development, is identifying land within the settlement boundaries, why is the second part not identifying land outside the limits to build development for development, but of a particular, only of a much narrower category? And in my submission, it patently isn't doing that. I mean, at that stage, there would be nowhere within Wiltshire that you could have that would be the subject, because everything would be identified. But the way to square that circle is to recognise that it's not what the policy is seeking to do. It's not seeking to identify that land. So, my lords, I've probably, I think, overtaken some of the submissions that I was going to make. And yes, my lord, it may be relevant in this regard to note that what is said in CP2 expressly refers to a presumption in favour of sustainable development, because as your lordships know and will have seen, sustainable development there is in itself a balance. Sustainable development means, yes, we meet the needs for housing and for employment, but we also recognise that communities have a need for employment, recreation, health, which require open spaces as well. Sustainable development does not mean all development. Sustainable carries with it the idea that within those settlement boundaries there will need to be a range of facilities, including open spaces, which need to be protected for precisely that reason.
I'll just ask, if you're right about the need for a greater degree of specificity, then the sort of thing which would operate as a trigger event would be a development plan which specifically identified something with the potential to be a village green or a town green for development. I'm just wondering how...
Well, my lord, that might depend on whether the village green was itself development. I mean, because would it be a change of use for it to be used as a village green? I mean, if it's being used for recreation at the moment, if that is its existing use, designating it is not a matter that it's not development that requires planning permission. If one had an arable field and wanted to turn that into a village green, so that the use might change from agriculture to recreation, then, my lord, that would be within the strict meaning of the Town and Country Planning Act. That would be development. It would be a material change of use for which permission was needed.
I'm just thinking about it from the point of view of the parliamentary draftsman.
Yes.
When they know about development plans, are they really envisaging that the only scope for a trigger event is where the development plan focuses in on something with potential to be a town or village green? Just find out.
Yes, it's my fault, my lord. I'm not entirely sure I'm understanding the point your lordship's making.
Just as a matter of your general planning experience,
yeah.
do development plans usually target down to the degree of specificity that says, well, this particular area which has potential to be a town or village green?
Well, my lord, town and village green is a status which operates under the Commons Act, and therefore a local authority would not normally allocate land or identify land as a town and village green. There may be an established town and village green over which it then applied, for example, an open space policy. It may be. Some may say that's otiose and unnecessary. A number of authorities may choose not to do it because it would be unnecessary, because the TVG status is all that is required to protect the land. But many authorities have policies. Much of Hampstead Heath, for example, is covered by a policy which identifies it as open space, and there are policies that are associated with that.
So there's no greater protection, is there, for against development than registration as a TVG?
Well, I hesitate to say no greater protection. There are a number of other areas of land which have fairly significant, but that would be a fairly high level.
You can even develop on green belt land.
Indeed, my lord, indeed.
You can't develop on a TVG. There's nothing you can do.
Well, it would be a very... my lord, the only reason I hesitate is because I can't confidently say it's the highest, but I would happily accept that it's up there at the highest end of the range. Yes. Yes, I'm not sure whether I've answered your lordship's question or no. I suspect I haven't.
I think you're getting there. It is a consequence of your construction that the development plan will actually have to focus on a piece of land which has the potential to be a village green. Right? I find that
My lord,
the more likely thing is it within an area?
My lord, in my respectful submission, it's actually the consequence of my submission that the development plan does not have to do that. Because, as I say, the limit to built development doesn't establish the principle of development on every piece of land within it. Right. And now, it is a point that I was going to make at a later stage in my submission, but I'll make it now because
how it could be
I think it is relevant to your lordship's question. If it is right that drawing a settlement boundary around a market town or a city effectively extinguishes the right to apply for TVG registration within that area, the only way in which one could avoid that consequence would be for the local authority in the first instance to carve out those green spaces where TVG registration is a possibility within its area. In other words, you'd have a settlement boundary that was like a Swiss cheese with holes in it. And my lord, in my submission, that's not... first of all, I don't know of a single local authority that has a settlement boundary of that type. But more to the point, it's not what the purpose is. The purpose of the settlement boundary is to define the outer limit of the built development of the settlement. It's not to indicate exactly what will happen within the areas.
In practical terms, barring exceptional circumstances, what would be the difference between the local authority drawing its settlement boundary as it does, but designating some places within it as local green spaces, and registration as a TVG?
Well, the local green space designation is a strong protection, my lord, but it's ultimately a policy protection.
Yes.
And it can be overridden in a way which town and village green cannot.
That's the point, that's the question I was putting to you before.
Yeah. Sorry, my lord.
Because
Yes.
local green space, as I understand it under the NPPF, has exactly the same protection as green belt.
My lord, in broad terms, yes. Yes.
So in planning terms, it's really the highest form of protection there can be.
In planning terms,
Yeah.
well, again, my lord, there's one that might top that, and that is if it was an internationally designated
Right.
ecological site like
Yeah.
an SAC or an SPA, and AONB.
So
maybe.
the Swiss cheese spectre is
Well-
not a real one, is it?
Well, but my lord, my lord, it is, because it requires the local. Again, I go back to the point. CP1, CP2 are said to be determinative in this case, and so the only way that you can avoid that is to carve out within the settlement boundary the areas that are not identified for development.
But determinative of what? Only determinative of whether a TVG can be registered. They're not determinative of whether development can in fact take place, because that will be dealt with by other policies. So if within the settlement boundary there is a local green space, or a listed building for that matter,
But, my lord, if one says it's identified for development, I go back to the bedrock of my submission that it's inherent in the idea of identifying something for development. You accept the principle of development.
Okay.
And if that's right, now, my lord, that may mean that a particular application was refused because, for example, it was too tall or approached too close to the boundary. But ultimately, there would be a form of development on that site that was permissible.
Yeah.
And the only way that you could avoid that, in my submission, would be the Swiss cheese approach.
Yeah.
Now, I say, as a matter of the way in which local plans are prepared, that will be wholly extraordinary. But it also has very real implications for the public participation in the local plan process, as your lordships will know. Local plans, a draft is published, it goes out to public consultation, people have the right to make representations, those are then considered by an inspector at the end of the day who prepares a report. In my submission, my lord, it would be utterly bizarre to expect a citizen or a member of the public with an area of green space outside their front door who thought that that was worth protecting in some way, shape or form, to object to the settlement boundary, which may be 5 miles away from where they live if they're in a large urban area, to object to that on the basis that somehow, by drawing that line around the outside, it meant that the space opposite them was appropriate for development. It would be extraordinary for people to understand that that was the implication of the settlement boundary, that everything within it was up for grabs. And it does have, in my submission, profound implications, not just for the way plans are drawn up, but also for participation in that process. Because it should be, if it's right, that the consequence of drawing a line around is that the ability to protect green space goes and is gone forever. It should be very, very clear from the outset that that's what the plan does. And in my submission, it
Well, wait a minute.
would not be.
Drawing a settlement boundary, if Mr. Jones is right, certainly suspends the ability to register TVG while the plan is
Yes.
in force. But it doesn't take away protection of the space forever. It transfers protection for the space
Yes.
from the TVG system to the planning system.
Well, it may result in the loss of the protection of the TVG status forever.
Yeah.
If subsequently
Yes.
if permission is granted and the scheme is built out, then effectively the suspension continues in perpetuity.
Yeah.
Now, and one could argue about whether logically the right has been suspended, but if it continues in perpetuity because there's a building on the site, it's been lost to all intents and purposes. And so there is the very real possibility that you could result in the total loss of a right which is accrued, or would otherwise have accrued.
And we have a familiar problem here between competing public goods, don't we? I think on the one hand, there's obviously a clear public interest in development not being upheld through nuisance-making applications or other delaying tactics. On the other hand, there is a public interest recognised in the Commons Act of TGVs being recognised for what they are, where the evidence supports them, and being registered as such.
And my Lord, that is absolutely right. But it goes back to the point, the submission that I've made about what is the mischief here. Because, now I can't speak for every single local plan policy up and down the country, but I've already made the point, and I'm sure my learned friend won't dissent from it, that...
I wouldn't bet on some of the evidence you've been given will be a subject of dissent, so don't take it as a
No, but the use of settlement boundaries, which I was hoping
on that.
Well, yeah, sorry?
Particularly, you should know that your evidence that you've been giving about settlement boundaries is not accepted.
Right.
It's not accepted that all settlement boundaries operate, as my learned friend says. You have to look at each plan. They operate, as my learned friend should well know, different way. We're looking at this settlement boundary. So my learned friend shouldn't accept that the evidence he's been giving for the last couple of hours is accepted. So I have kept quiet, but he offered the invitation, so it's not accepted. And I'll deal with it in due course.
Well, my learned friend won't accept it, my Lord, but certainly settlement boundaries, in my experience, and your Lordship could look at any number of cases to see how frequently settlement boundaries are an issue. Settlement boundaries are a common device.
Yeah.
They are commonly used to distinguish between open countryside and...
We've got your submission on that.
And I do say, my Lord, if I'm right, and if that's the basic question is, where are you trying to steer development? If that of itself is regarded as identifying land as suitable for development, then large parts, very, very, very large parts of this country will discover that the right to see TVG registration has gone in circumstances where the land over which they wish to make the application has never been at risk or threat. This is not a situation where you've got a particular
You've made that point, Mr. Brown.
My Lord, I'm grateful. My Lord, those were in essence my overarching submissions. Can I just deal briefly, and I will try and make it as brief as possible, with the judgment of...
I think you were going to show us where the judge went wrong.
Well, my Lord, I hope to. Your Lordships have the judgment at tab 6. And the Deputy Judge's discussion of the role is recitation of the relevant law starts at page 64, paragraph 26. He sets out the relevant provisions. Can I take your Lordships, please, first to paragraph 33, where he says, in my judgment, the purpose of the requirement to identify the land for future development is to create a sufficient nexus between the plan and the land so that it doesn't fall within paragraph 4 simply because there are plan policies that generally encourage certain categories of development or in certain circumstances. To do so would unduly restrict the section 15 right, since many, if not most, development plan contains policies that may be regarded as positive in nature without specifically identifying the land. Parliament's required in paragraph 4 a more specific nexus than a plan which simply creates a potential for future development and aligns more closely with the statutory purpose by requiring that the plan identify the land. My Lords, I agree entirely with what's said there, in particular in relation to a sufficient nexus. It is not enough, in my submission, that the plan simply encourages certain categories of development. I take your Lordships to paragraph 33 because I invite you to contrast it with what the judge later says at paragraph 66. If your Lordships keep a finger in the page at 33, page 76, paragraph 66. Deputy Judge says at several points in his skeleton and argument that Mr. Morgan suggested that land wasn't sufficiently identified, but I consider that the issue under paragraph 4 is simply whether it is identified for potential development, and it's unnecessary to gloss the statutory language to include a requirement of sufficiency. Well, my Lord, in my submission, it's very difficult to reconcile that with paragraph 33, where the judge himself recognises a need for a sufficient nexus. moreover, my lords, for the reasons that I outlined in my initial submissions, I don't recognise or accept that the concept of sufficiency is putting a gloss on the word identify. In my submission, the word identify carries with it an inherent requirement of specificity. It's there in the word. One doesn't identify something by narrowing the field. Don't identify land for the development by saying it's with, there is some land within a wider area will be suitable. So that's an observation, mainly, my lords, directed at paragraph 66, but founded in paragraph 33. Your lordships will see paragraphs 34 and 35, the reference to Mr. Justice Lindblom, as he then was in West Kensington, and paragraph 35 is where Mr. Elvin says that the same approach, using the Oxford English Dictionary definition, is true in relation to this case, and I respectfully adopt and endorse that particular part.
So, I mean, in effect, what you're saying is that he's not carrying through his own self-direction.
My lord, yes.
He's directed himself correctly on the law in
33.
Paragraphs 33
Yeah.
to 35, but
Yeah.
when he comes to apply it,
That's where it goes, yes, where I differ, respectfully. My lords, paragraph 44, CP2 identifies a series of strategically important sites. This makes it clear, which isn't disputed by the Council, CP2 is not intended only to set a strategic framework for other plans, but to manage development. It's a policy that could be used to judge the acceptability of a development proposal. I've already indicated to your lordship, I don't dissent from that. I recognise that CP2 has a development management function, but I don't accept the conclusion or the inference which is drawn from that, that because it has a development management function, it of itself identifies land. I go back to the point that's said, made in paragraph 33. There are some policies which encourage development, but aren't necessarily capable of identifying, and in my submission, whilst CP1, CP2 encourage development in urban areas, they don't identify those urban areas. The development management point, with respect, is of limited relevance. Paragraphs 48 through to 50, the learned Deputy Judge refers to the supporting text, most of which I hope I've shown your lordships, but at paragraph 51 he says, it's notable, notwithstanding the above sources and strategically important sites, the delivery in CP2 does not limit development to sites so identified or those allocated in the plan or other plans, and draws a distinction between development within and outside the settlement boundaries. My lords, I accept CP2 doesn't limit development to sites which are identified as strategic sites. It clearly has a number of strategic sites that are identified. It also clearly recognises that additional sites will be needed. But again, my lord, in my submission, that doesn't get one over the next an important hurdle, which is, does it mean that sites are identified? Yes, additional land will be needed, but it is not establishing the principle. It's a general steer, but not a sufficient nexus between the land and the principle of development. My lords, paragraph 52 then makes the point that there are, even in the case of strategically important sites, of which Fuggleston Red, which your lordships looked at very briefly previously, was an example, that even there the policies themselves impose certain constraints on the development that may come forward. Well, Lord, that's correct as far as it goes, but one needs to see and to understand what the conditions are, because we can go to Fuggleston Red and the conditions that are there if need be, but in essence, my lord, in my submission, what one sees is things which may constrain or limit the extent of the development, but nothing which actually undermines the principle.
Yeah. The submission you made a few moments ago is that the land must be such that ultimately there would be a form of development that would be acceptable.
Indeed. And in Fuggleston Red, my lord, it may be that some parts of it along the boundaries, for example, are kept for screening purposes. There may be an area of open space that needs to be retained in the middle somewhere to provide a playing area. But there is no doubt in terms of the policy that development of some sort will come or should come forward on that site. And that's the key point. My Lord, paragraph 59, Learned Deputy Judge agreed with Mr Jones' point. Land doesn't have to be identified by the use of a line on a plan. It says the fact that it is so identified is sufficient to bring it within paragraph 4. My Lord, I respectfully accept the first part, but I have difficulty with the second. I recognise that a line on the plan is not the only way that you might identify land. You could do it in words that were sufficiently precise. But I do, in my submission, disagree with the conclusion that because you've drawn a line around something, that means it's identified for development. You have to ask what the purpose of the line is, and I don't go back to the submissions that I've made about the purpose of the line in CP2, but your Lordships have that point. Allocation is described, paragraph 60, by Deputy Judge as a paradigm example, but indicates that there could be other ways of doing it: preferred areas for development, opportunity areas, reserved areas, accepted. Again, my Lord, I don't quarrel with that, but I do say that if allocation is not the only way, the other alternatives need to give a comparable level of confidence that the principle of development is accepted. There needs to be that clear establishment of the principle. And then, my Lord, if I can go to paragraphs 64 and 65. Paragraph 64 notes that the boundary identifies an area which is much greater than the land, but it's not disputed by the Council, but of itself that's a bar to treating the plan. Mr Morgan was unable to formulate an approach in terms of scale which would necessarily preclude identification through a settlement boundary. And then 65, the existence of potentially significant number of constraints doesn't take the plan or policy outside paragraph 4. And
is it still not disputed by the Council that an area of land greater than the particular parcel is no bar? Do you still accept that, or do you say
Lord,
that's wrong?
No. I don't take issue with the point about scale. I mean, there are some very, very large allocations of land. Yeah. If one thinks about land that's allocated, for example, for garden villages or garden towns, and that land is identified for development. The point, my Lord, is not the scale. It's what is it that the policy is doing by drawing the line. Now, with a garden village allocation, yes, that policy is identifying the area as for development or for potential development. But just because the line may be large, it may be small. The question is, what is it that the policy does or tells you? What is the significance of that line for the land that is within it? And that's the point that I make. It's not a point about scale, in my respectful submission.
But can I just come back to a point you made earlier on, that you said that narrowing the field is not good enough. I mean, if there were a policy which said housing development will be permitted on any greenfield site within 250 metres of a railway station, is that, suppose, it may be an unrealistic policy.
Well, my Lord,
could you not show that my site falls within this description? It's not the only one.
Well, my Lord, that's why I recognise that one doesn't have to have a line. That's a form of words. Yeah. Would it be sufficiently precise?
But there may be, say, 10 sites that fulfil the criteria in the policy.
Well, but my Lord, that doesn't mean... the policy doesn't... It can't... or the wording identified potential development. There's nothing that the Act or indeed a local plan can do to compel development to come forward.
Of course not.
What the plan can do is identify it so that when it does come forward, it tells you, if I put in an application for permission, now there might be arguments about the detail, but is the principle of development acceptable here? And my Lord, if one had a policy which said, any greenfield site within 250 metres of a train station, which I think was your Lordship's example, permission will be granted. Those words are precise, they're comprehensible. I would struggle to say that simply because it was a line, that land had not been identified. I would struggle with that. I reckon, but I don't need to struggle with it for the purposes of my submission. It's not this case.
No, I follow. I'm just trying to...
I take that point. So, my Lord, that's paragraph 64. It's not about scale, it's about purpose. On constraints, your Lordship have my submission on the constraints point. The paragraph 65 does go on to comment on the breadth of the word potential. It says it's a very broad concept, not qualified, not to be equated with likelihood or probability. My Lord, in my submission, one has to ask, when it's talking about potential development, what does it mean? It goes back in my submission to the point I've just made. The plan can't compel development to happen. It may or may not, and in that sense, it is potential. But the identification for potential development has to be precise. And you don't identify something for potential development by saying, well, it may or may not be acceptable here.
How does that compare with the other type of trigger event of a planning application? Because a planning application may be sufficiently precise in terms of...
Well, planning application will be.
Identify
Yes.
the area, but question whether or not you will get permission or how suitable it is for development doesn't arise at all.
No,
those
but my Lord, the words identify the land for potential development only apply in relation to the development plan policy.
I understand that, but I just wonder why we're bringing in all this consideration of to use your language, there's a comparable level of acceptance that the principle of development is accepted.
Well,
why should that be so for development plans, but not for planning applications?
well, my Lord, I'm focusing on the wording that is specific to development plans. The schedule has different...
Comparing it with the other type.
Well, my Lord, indeed, I understand that. But the legislation deliberately uses different language in relation to a plan. If land is within the area of a planning application, we go back to Schedule 4.
Yes, I understand that.
The fact that it's within the area is enough to suspend the right until the outcome of that planning process is known. Either the planning application is granted and goes on, or it falls away because there's been no appeal, or it's refused, or legal proceedings end. And so, I mean, the reason why I've focused on establishing the principle is because I'm looking at the words which are specific to what is required of a development plan. In the context of a planning, it goes back to the mischief point, my Lord, that if you've got a planning application on a particular site, the local authority may or may not have ever thought about developing this land, but the developer has. He's come forward, and all of a sudden he's faced with a situation where a scheme which may or may not be acceptable at the end of the day, but that is suddenly put on hold, potentially stymied, because of the TVG application. And there's a clear desire to prevent that happening, particularly in circumstances where, as is often the case in the country, local authorities aren't necessarily bringing forward land fast enough in order to meet needs. So people are bringing forward sites that aren't allocated, sometimes outside settlement boundaries. In essence, in crude terms, one of the things the legislation is doing is saying to people who want to protect village greens, if you want to do this, you've got to get in first. There's not, you can do it, but what you can't do is simply respond to somebody else's proposal. Because it's the responding which allows the abuse of the process, the putting in the spoiler application for registration, which simply kicks everything else into the long grass.
So you say there's a distinction between an individual planning application, which involves a particular developer, and a blanket development plan, which raises other considerations.
Well, they are different. But in either case, I do say that there needs to be a comparable level of specificity as to the land being identified. And with a planning application, the land will be identified. There will be a red line drawing which shows you exactly what is proposed. So in that sense, perhaps, my Lord, identification is, one doesn't need to talk about identification in that sense. It's inherent in the planning application that the land will be identified. But going back to the mischief, there is similar. I would argue that there should be a similar level of specificity that one expects when one looks at the words identified for development in a development plan. That's my point. Yes, my Lords, I think and hope that those are. Lords. Unless you have any further questions, those are my submissions.
Thank you very much, Mr. Brown. Yes,
Thank you,
Mr.
my Lord.
Jones.
Just to let you know how I'm going to approach this, first of all, and before lunch, deal with, I'm going to bring us back to the actual wording of the Act.
Yeah.
I'm going to deal with the statutory, the primary method of statutory interpretation, which is actually looking at the meaning of the words. I'll then turn to the mischief and take the court to some of the documents you haven't been taken to, insofar as one needs to look at it. And then I'll move to the actual policies, which will be after lunch. I do agree with my learned friend that when, in answer to my Lord's question a moment ago, one does look at the actual statutory wording that was used. And our first submission is that the word potential was carefully chosen. I made a note of my learned friend's relevant ways in which he has cast the test before your Lordship. Very often he puts the test as identified for development. Then he puts it that it must be suitable for development. Then he's put it as it must be acceptable for development. And then he has also put it on the basis that the principle of development must be established in the plan policy on that site. So that something, well, they didn't actually address what sort of development he had in mind, because development, although one might not have appreciated it from a learned friend's submission, includes both change of use, and that could include a listed building to a residential use, could involve, as my learned friend agreed, change of use, as it would be in this case, to recreational from a nil use or arable use, which this site would be. So the key aspect, therefore, is why did Parliament choose the word potential? The second point is my learned friend seeks to elide, impermissibly, two things. He seeks to elide the word identify the land with how you interpret the word potential. There is no question, as a matter of fact, this land in question is clearly identified, and it's clear what policies apply to it. The identification of the land for potential development does not import any higher test than the word potential ordinarily has. The learned judge was quite right. If the draftsman wanted to say for acceptable development, development in principle acceptable, go down the list of my learned friend's words, suitable for development, or likely for development, which is another way of casting my learned friends. Or he at one stage uses the word sure. Got to be sure that some form of development will in due course come forward. Just argue about the height. Why then, we ask rhetorically, did the parliamentary draftsman not use that wording? One, they use that wording because that is not what they intended. And when we look at the mischief and also the process of what we're looking at, we know very well, because the plan process is a process, and you've seen a little bit, my lords, of it. And we'll see that precisely what the core strategy does is identify land for potential development. That's the word potential development. And indeed, if I could just ask your lordships to go to the core volume 1, page 229, and we didn't actually, and we were taken by my learned friend briefly to the council's supplementary response to my opinions. And this is at page 229. And my learned friend, I agree, it's right that even if the local authority had asked itself the wrong question or the right question, this is a pure matter of law. The interpretation of planning policy, when we come on to it, is a matter of law as well. as established by the Supreme Court in Tesco and Dundee. So we look at 221. Can I just ask your lordships to look again, trigger events and what was said? 229, my lord. Tab 18. And halfway down, it matters not as a matter of law whether the registration authority thought they were bound by their planning department. That I think they were wrong, but it doesn't matter. The planning officers are believed to have sought their own legal advice on this point, although it's unclear, but never mind. But the main point is this. The purpose of the settlement strategy is to provide framework and identify areas of growth where development will be focused, and it provide the basis for future decision on potential development in identified settlements with it, which include market towns and community areas. Without more, the settlement hire cannot be considered to undertake specific to identify land for development. The core strategy is therefore not aimed at specific sites within the neighbourhood, both of which would be site specific. Now the issue there is we know, however, that what the plan actually does, and we'll come on to it, is precisely that. It does identify areas for potential development, and it identifies land to which the policy for potential development applies. So we return back to page, it's 2 of the tab A of the authorities, the actual trigger events. One sees above subparagraph 4 that we focused on that the trigger event is also triggered when a draft, this is paragraph 3, of a development plan document which identifies the land for potential development is published. So the authors are aware that once you publish a draft for potential development, this may trigger applications for village green applications. So if you have the position that if my learned friend is right, and we'll come on to the mischief and the plan later, but let's just test it, that CP1 and CP2, this authority has decided it's not going to go for a new town approach, it's not going to go for a scattered approach around all the villages, it's going to have a hierarchy approach. It's common, but not unique. That's a planning choice. And in so doing so, it is identified, as we've seen, and we'll come to, areas, we say, for potential development. Identified them very clearly. If my learned friend is right, having been told in the plan that these are the areas where we are going to look to make our housing numbers. So a view is taken on the potential, as we've seen, of whether or not the core strategy is sound. It will have to show that those areas identified for potential development have a likelihood of delivering that number of housing or retail or infrastructure. Mainly now it all focus on housing numbers. If my learned friend is right, at that stage you can go off and apply for your village greens and support that process. Because no draft will have been published, because he says it doesn't say in any of these areas where we've identified where we're going to put, that's where all our potential development is going to go. That's not good enough for my learned friend. So the whole mischief will be back in play to run off and make your applications. So when we come back to the wording is entirely consistent with the purpose, because in respect of development plans, it is just highlighting potential development. The word, my only friend made his last submissions, he accepted that an allocation was good enough, but he said any other policy needed to be capable of a level of certainty equivalent to an allocation. Those were his words. And in our submission, that is plain wrong and contrary to the plain wording and intendment of the legislation. Allocation, as your lordships know, and it's not before, but if there's an issue, has a statutory process. You allocate through the plan process later on in the planning process. So if my learned friend is right, effectively this legislation, insofar as it applies to development plans, is castrated at birth.
Oh, well, I think we've got the definition, haven't we, of allocation in the regulations in the West Kensington case.
Your lordship has it there, and it appears in various...
13, it's a policy which allocates a site for a particular use or development.
Yes. So, my lord, the question I just asked rhetorically, that concept is well known in planning statutory framework. If Mr. Brown's submission is right, why didn't the authors use the term allocation? Why didn't they use any of the other terms that he uses? And the reason is because potential is exactly at that early stage level. You have the potential to be a very good footballer. Mr. Brown has the potential, which he's fulfilled, of being an excellent barrister. But not everyone fulfills that potential. And that is inherent in the word potential. It doesn't require a degree of likelihood. It requires a degree of prospect. So I reject, we reject, as contrary to the plain wording. And my learned friend doesn't actually, in his submissions, identify and face on to the meaning of the word potential head on. What he says is, it's encapsulated in the word identify. Identify for potential development means, and the various iterations. The next point I'd just like to make, my lords asked my learned friend about the position with a planning application. And my learned friend said, well, that's all very clear, and people know where the red line is. Well, as it happens here, there's no question of identifying the land. But of course, another difference between this piece of the effect of this act and my learned friend's submissions is that this acted retrospectively. This legislation applies to plans that were adopted before the legislation came into force. So plans that have gone through the process without any knowledge that this measure might come forward. So that gives a reflection of, in our submission, how the drafters intended the balance, if you like, to operate. And of course, what we do know, when we come on to look at the plan, my learned friend says, for the purposes of this, it's CP1, CP2. Remember, for the purposes of this, there hasn't been any other policy relied on by the local authority in respect of this appeal. I'll come on to deal with that policy, which they say thwarts it. But we'll come on to that in a moment. Could I then just ask your lordship, whilst looking at the question of the trigger offence, just if we could, my learned friend took your lordships to the DEFRA guidance. We also, which is at tab L, and paragraph 3, page 1.
Do we get any help from the consultation paper, which is referred to in that paragraph?
My Lord, we get limited help.
I think it was the consultation paper which introduced the local green space designation, said it was going to, and tied it together with the change in the comments.
Yes. My Lord, yes. I mean, we get the help in the sense that, as your lordship had said to my learned friend, and I understand he didn't disagree, there was a recognition that the green space the introduction of the green space system in the planning system would offset some of the impacts of the legislation which removed the ability to apply for registration.
The purpose initiated by the Penfold Review was to
Cut registration.
push it all into the planning system.
Yes.
And not allow TVG registrations to cut across the planning system.
My Lord, that's right. And that was the whole purpose. I mean, Mr. Brown's submissions effectively, if they are in terms of the plan-making process, would be business as usual. I mean, there has to be a recognition that it was intended to make a quite radical change in the system, as my Lord says, to move these issues of protection for those that hadn't registered before. Either there would be a suspension in the case of a planning application that may not be determined, or that it would be local authorities would look through the planning process to deliver these sites. Bearing in mind, if one looks also at, we've put in the documentation in another case, in which appear, we have the skeleton argument of the Secretary of State and the affidavit from there.
It's not going to help in the slightest.
But all one would see is it sets out in the affidavit, in slightly fuller terms, what's said in paragraph 3. Yeah. And is consistent. And
it contains an inadmissible reference to what was said in Parliament.
Yes. Well, in fairness to the author of the skeleton, I think, and they were saying, we don't think that you need to go to Parliament. You look at it on its plain wordings, but if the court's against us, this is what it says. We adopt a similar position to the Secretary of State. You look at the actual wording, potential. You don't rewrite it, as my learned friend does. And there is no getting away from it. If your lordships go with my learned friend, you are having to rewrite the ordinary wording of the statute on the basis, and my learned friend didn't shrink from it, the sort of floodgate, scaremongering, apocalypse of that he presented, which I'll come on later and show why that's flawed in any event. But there's no justification from going away from the ordinary wording. So turning then to the issue of identification, we said there are two ways one looks at that. One, identification of the land, and we don't believe that's in dispute. Secondly...
Well, I think it is, actually, because I think Mr. Brown's point is you don't identify a particular piece of land by, as he puts it, narrowing the field. So just because your piece of land is within the settlement boundary does not identify it.
Yeah. I've got 2 points. That's his second point. The first point is where the land is and whether it's within the policy or not is not in dispute.
Right.
The second point really is Mr. Brown's dispute about what is the land identified for, and really what he's doing is aligning identification with the question of potential development. I don't think, and I may be wrong, that Mr. Brown did not submit to your lordships that if the ordinary use of the word potential development is used, he has any issue that the land is identified for potential development. What he says potential development means is must mean something else, he says, because of the mischief. So we do have a situation, my Lord, when we turn to the policy, although I don't accept that you need to show that that there is some form of acceptability in principle for the development, we have in the policy a policy approach which says if you're within the policy, there's a presumption in favour of sustainable development. That is presumed to be the case. All planning policies are rebuttable. All policies are policies, not laws. That's actually higher, we say, than you actually need in order to satisfy the test, because it comes with a presumption that development will be presumed and the land within it will be presumed to adhere to the principle of sustainability. Hence, the presumption in favour. If you're out,
I'll just unpack that last.
yes, well, that's
Why is the development presumed to comply with sustainability?
no development.
Sustainable development is presumed to be acceptable, but it doesn't follow that development is presumed to be sustainable.
But well, let's go to the policy, and then we can get the in terms of the policy.
Right.
And let's go through. We go to the supplementary bundle, and I can take this shorter because there's some. I'm not going to repeat of it points my learned friend took to, but there are some other points I'd like to highlight. So we go to tab 1, my lord. Mm-hmm. So we begin with the strategy. So this is the strategy at the. And my learned friend took your lordships to 1.3, and I won't read that out, but we will see that the strategy here is a policy-led framework for concentrating development at different levels of the hierarchy and maximising that development at the higher levels, and then drawing a boundary as to the application of those policies that seek to push development into that direction. And so if one goes to chapter 4, delivering the framework, 4.3 that we looked at sets out the 3 key elements. First of all, the first element is the role and function of the settlements, and then the delivery identifies the level of growth and how Wiltshire settlements will develop the most sustainable fashion. So what they've decided is that the most sustainable form of development is this spatial strategy. Other planning authorities may have different ideas. This is what Wiltshire have done. And they identify, first of all, a hierarchy of settlements, and identifies the level of growth that those settlements are in. And if you're in those settlements, that is where the potential development is going to be. So if you're land within it, you are land identified for potential development.
One has to have some limitation on the word potential, doesn't
Yes.
it? Because, I mean, if you press it too far, any land has potential for development, even if there's a rebuttable presumption against development.
Yes.
I mean, it's in exceptional circumstances it could be. So even greenbelt land, on that argument, would have potential for development. That plainly can't be what Parliament means.
But that's only taking the one word, my lord.
Well, I know, but you were rather asking us to focus on the word
No,
potential.
no, no. I'm asking, identify there's been lots of focus on identifying the land, but it's in the plan. The difference between your lordship's point, with greatest respect, that all land has potential development, is whether the plan identifies the land for potential development.
Yes, that rather makes a point. It's a composite phrase we have to interpret.
Well,
And of course
that's
we
my
have to look-
point.
We have to look at the component words, but also have to stand back and examine the overall concept which Parliament had in mind.
Yes, and it's very clear the concept Parliament didn't have in mind, which is what my learned friend says, is that you need an allocation of land, or you need an acceptance in principle of development.
Well, that's not self-evident to me, I have to say. I mean, it seems to me that may be precisely the kind of level of particularity which Parliament might have found.
Well, my lord, if your lordship's of that view, it's not the meaning of the word potential.
Well, it's trying to tease out the concept which the phrase as a whole is aiming at.
Yes, identifying the land for potential development. So, for example, subject to exceptions, what we know in planning terms, that if you're outside, so if we came to Wiltshire and we see the development boundaries and we see we've got an open site within the boundaries with those policies, we see that this is a site that may be potentially developed. If, although there are always exceptions, you're outside those boundaries, the presumption is that you won't be developed for housing. So that is what the use of the word potential identifies. Plans are intended to give a guide, as my learned friend says, the guide to where development is intended to take place. So you come to the core strategy and you say, where does this core strategy identify what land is identified as land for potential development? Well, the land identified for potential development, in this case we're focusing on, is land within those boundary limits at Wootton Bassett. That is all land identified as potential development. It's not necessary to show that that development is likely to come forward or will be acceptable in due course. Even with an allocation, there will be areas of land. Let's take Maloney Friend's example of...
Take the example of a playing field.
Yes.
Suppose that there's a planning policy, I don't know whether there is or there isn't, that loss of playing fields will not be permitted, or not be permitted unless they're replaced, or whatever the policy is.
Yeah.
Is that land identified for potential development?
It may or may not be. First point is, and this is where I take issue with Maloney Friend's evidence, first point, I don't think you can take issue, it's commonly accepted you read the development plan as a whole. So we're not looking at plan policy, we're looking at a development plan as a whole. Second point is, sometimes planning policy is pulling up different directions and you have to make a decision as to what the plan as a whole means.
Yes.
Third point is, it is open, and I didn't see any difficulty with what your Lordship was suggesting to Maloney Friend, that if you craft a plan in a particular way, and you did CP1 and CP2, and then you were Wiltshire and you now think, oh my goodness, we're worried that playing fields, we've got no protective policy for them. You can draft your policies very clearly, and this is where I take issue with Maloney Friend. Maloney Friend was presenting your Lordship with this notion that all around the country, everyone draws settlement boundaries, and you're either in and it's a free-for-all, or limited free-for-all, or playing fields, or you're out. That is not the position. Local planning authorities make their own planning judgment as to the extent to which they may want to restrict development even within the development areas. So, my learned friend said it was Swiss cheese. That's not Swiss cheese. If you wanted to take land out of the CP1, CP2 for potential development, you could do that. You could do that.
What, by a different...
By planning policy, yes. You draft your policy in a different way.
So let's just...
I think there's
just work this one through. So, somebody says, I wish to... Mr. Godsnell says, I wish to register this piece of land as a TBG. The registration authority sees policies CP1 and CP2 and says, yes, well, it's within the settlement boundary, so on looking at it from that perspective, there seems to be a trigger event, you would say. Now do we look through the rest of the plan to see if there are other policies which, so to speak, disidentify it for development, to see whether it's protected by open space policy or...
You've got to look at the plan as a whole.
Yeah.
So the answer is yes. Second question is, however, if you're in the position we say we clearly are, that it's identified as potential development, he can't register. If the local planning authority is worried, as Mr. Brown says they're worried about all other sites, they should review their plan. That's the way Parliament expects it to be carried out.
And what are, forgive my ignorance, but how do you review a plan midway through? Do you just do it and put it out for consultation?
You have processes that you have to go through. So you can either, sometimes you review your whole plan, sometimes you review parts of your plan.
Right, and there's a procedure for
There's a procedure, consultation, and such like.
If they wanted, for instance, to designate this piece of land as local green space, they could do
Yes,
that?
yes,
Or a neighbourhood plan could do that?
yes, yes. I mean, my clients and others would have the ability to object. Yes, of course.
They would, yes.
Yeah, no, absolutely. And that's, as your Lordship pointed out, is the way in which it's envisaged to come forward. It's not just the delay caused by unmeritorious village green applications, it's also the problem. This local plan, as we've said in our skeleton, has made an assessment of its housing delivery. It's a rather odd position. We've got the registration authority, although it's a unitary authority, but its planning authority is relying on this plan to deliver. And it's doing so on the basis of calculation of various deliveries from these settlements based on these settlement policies. It's not saying, oh, we've got to discount for a number of village greens that could come forward. So it's justifying having a 5-year housing supply on the basis of this and other plans. And it's assuming that, that these sites where it says potential for development, and you've seen the indicative numbers, so the indicative numbers that are indicated and relied upon, if we go to
2070.
Yeah. Where are they coming from? They're not allocations within Wootton Bassett. They're based on it being subject to CP1 and CP2.
Well, I think the text says they don't need allocations this early in the plan.
Yes, because they're already in that policy thing. But there's an assumption. Where are these allocations going to go? They're all suddenly then I can get my village green applications in now, if Mr. Brown is right, on all these on potential sites, and that's the end of Wiltshire's moving to the next stage.
Right, so will this be a convenient moment for you to move to the next stage?
Yes, or do you want? Does that mean lunch? Or?
Yeah.
Yes, rather than the next point. My lord.
Part 2.